and whether you need a record or not. First up, we have Helton versus Middleton.
Kendall Bryant. Oh, I'm sorry. Kendall Bryant here for defendants and third-party plaintiffs. We are the respondent to third-party defendants' motion for summary judgment. We also filed objections to evidence that we will need a record on. I think we can get everything done in about 30 minutes, but I will defer to my opposing counsel on what she thinks too.
Raker Rorty for the movement. And Your Honor, I would agree with 30 minutes, probably less.
Okay, and we just need a record for the objections, I take it?
Yes, Your Honor.
Okay, we'll take those up at the beginning. All right, thank you. And then next we have Allen versus Costello et al.
Judy Costura here for the movement, Your Honor. I'm not aware of anybody here on behalf of Ms. McIntosh, and we have consents from the three opposing counsel to this withdrawal. So 20 minutes is what we announced, but it may be considerably less.
You don't need a record, I assume.
I do not, Your Honor.
Okay. Anyone else here on that?
Yes, Your Honor, this is Alma Aguirre. I'm counsel for defendant Justice Sand. The motion is unopposed by my client.
And yes, Your Honor, I'm Kate Freeman on behalf of Sandvik Mining and Construction USA, and we are similarly not opposed.
And Your Honor, Daniel Moreno here on behalf of the other plaintiffs, the Allen plaintiff. Your Honor, we are unopposed.
All right. Thank you so much.
And we have filed a proposed order, Your Honor.
Okay, great. I think we have that here. So next up we have Karam versus Dynamic Glass.
Stephen Vega, Your Honor, for defendants and movements. It's a traditional and a no evidence motion for summary judgment.
Okay, and we don't have anyone here on the other side. Is that correct?
I don't see anyone here associated with plaintiff, Your Honor, and I will also add that no response was filed to this particular motion.
I saw that. Okay. You don't need a record.
I do not.
Okay, and I imagine it will be shorter than your 1 hour announcement.
Yes, ma'am.
Okay.
Yes, ma'am.
Thank you. All right, and then we go to Barrage versus Alfano.
Chris Campana here for the plaintiff and the movement. I don't anticipate it'll take more than 10 minutes, probably much, 5 minutes, and we don't need a record.
Anybody else here on that? Do you see your opposing counsel in the courtroom, sir?
No, Judge, I don't, and I've tried calling him for the past 2 days, and I haven't heard anything back from him, so, but I'm sure, I know we sent him notice of the hearing, and I know he got it from the court that we're going to do it remotely, so, no, I have no sign of him.
Okay, well, while you're waiting, if you wouldn't mind giving his office a call, just see if you can track him down, as a courtesy, the court would greatly appreciate that.
I will, Judge. I'll try him on his cell phone. I think that's the only number I've had any luck reaching him, but I'll try both.
Okay, find out whether he intends to join us, if you
I will.
Thank you so much. All right. Let's see. I am going to move to the motion to withdraw. It is arguably the shortest item on the agenda. And Ms. Costura, Ms. McIntosh has been noticed and has not either filed a response and has not appeared here today.
That is correct, Your Honor. And this is actually something that has been in the works since at least May of 2024, and we've had absolutely no response from her since that time. We had an earlier setting, which because of some technical reasons didn't go forward. She didn't respond to that one either, and we e-filed this morning notice, a copy of the notice that we sent her with the Zoom recording information after previously giving her notice of the hearing, and we've simply had no contact from her.
Okay. Fair enough. And let me just ask, I know the defendants who've appeared have told me they don't oppose the motion. Anything else anyone wants to offer on this?
Your Honor, thank you.
No, thank you, Your Honor.
Same for you, Mr. Moreno?
Nothing from me, Your Honor. Thank you.
Okay. All right. And Ms. Costura, when I sign these motions, orders on withdrawal motions, I like to include the address, email, and phone number. Is that something that I don't think that was included in the proposed order. Is someone able to update that proposed order so that we can include that?
We will certainly get that to you. Do you want that sent to you on the submission docket?
Either Ms. Seeger or the submission email will be fine.
Okay. I believe that was part of the motion, Your Honor, but I'll make sure it gets included in the order, both the address, email, and phone number.
Perfect. Thank you so much. The court will grant the motion to withdraw.
Thank you, Your Honor.
And you are all free to go, excused from our virtual courtroom.
Thank you, Your Honor.
Thank you.
Take care, everyone.
Thank you.
Thank you.
Thank you, Judge.
Let me just take a look. Mr. Vega, your
Yes,
motion
ma'am.
is traditional and no evidence, and we know without a response to at least the no evidence portion that the motion's probably ready to be granted, at least on that. I don't know if
Yes,
you want
ma'am.
to lay out the traditional motion as well.
I can, Your Honor, and I think that, obviously anytime opposing counsel doesn't file a response and certainly doesn't appear at the hearing, that may give Your Honor a little bit of trepidation about that situation. But if I could just explain the facts and the claims that we are seeking summary judgment on, perhaps that would make the court know that this is not a dismissal of the entire case. And really, it's just eliminating what I think are claims that either have no evidence or are no longer valid given the circumstances of this particular case.
Yeah, go ahead and run through that for me.
Okay, yes, Your Honor. This case involves a motor vehicle collision. My client, Gregory Cosby, was an employee of Dynamic Glass. They are the two defendants in this particular case. The facts of the case will show that Mr. Cosby made a left turn at an intersection on a solid green light. Before he could proceed through that intersection, plaintiff's vehicle coming from the opposite direction clipped the last foot of his 53-foot trailer. That's the basis of this particular lawsuit. Several claims were made in this case. The case has been on file since 2022. This accident happened in August of 2021. So again, it's been on file for some time. The causes of action that they alleged against my driver were negligence per se, and also gross negligence. The facts of this case, Your Honor, will show that our driver had a valid driver's license at the time of the accident. He was driving a non-commercial vehicle. So it's any vehicle that any one of us without a commercial driver's license could get behind the wheel and operate legally, could operate that particular vehicle and trailer. Also, the evidence shows that Mr. Cosby had taken this particular route on this day between 50 and 100 times. It's a work route that he does from time to time, driving this same vehicle and same trailer. And so it was a route that he was very comfortable and familiar with. His testimony shows that as he made that left turn, he did look. There's kind of a curve on that road. but he did not see any vehicles oncoming. And so because it's a 53-foot trailer, he makes that long, slow turn. He was just unable to clear the intersection at that particular time. We are not moving for dismissal of the negligence claims against Mr. Cosby. So those will survive and those will go to trial. We are set for trial on January 27th, which is why this is the absolute last time that I could have heard this particular motion. And so those negligence claims will survive any summary judgment here and will move forward. There is absolutely no evidence of gross negligence under the facts that I just presented to you. His driving record shows that he had one speeding violation in about the 11 years before this accident, and that's it. Quite frankly, off the record at a recent expert deposition, plaintiff's counsel did indicate to me that he intended to non-suit the gross negligence claims, but just hadn't done it, which forced me to file the motion for summary judgment to have that heard. He also has filed some negligence per se claims. And Your Honor, looking at those particular negligence per se statutes that he identified in the petition, none of those require any sort of different analysis than just your standard negligence, reasonable person standard. And so those, what case law, and I've cited those in my motion, what case law says is the exact ones that he referenced in his pleading are not separately submitted to a jury because they are just regular, ordinary negligence claims that can be heard under those negligence causes of action. I would like those summary judgment granted on those, just so that there's no confusion at a later time once we do go to trial. The claims against the company, in addition to respondent superior negligence, and again, we are not contesting that he was in course and scope, so there's no argument there. We're stipulating to that. Also, there's no evidence of gross negligence against Dynamic Glass, given his clean record, given the fact that he had a valid license. There simply is no basis for gross negligence in this particular instance. And again, he did indicate to me that he intended to non-suit those particular gross negligence causes of action. Because in addition to all of that, there are also other direct negligence claims against the company: hiring, training, supervision, retention, and so forth. Again, this particular driver, valid driver's license, he had experience driving this particular vehicle, had no prior incidents in the almost 2-3 years that he was employed with the company. So there's absolutely nothing that the company was aware of that could have caused a danger to anyone, or that he was unfit to do what he was doing on that particular day. We have cited some cases that talk about those standards, but again, because it is no evidence, and also the evidence does show regardless that this particular company did not breach any direct negligence claims. In addition to that, Your Honor, under the respondent superior admission rule doctrine, because we are not contesting course and scope that he was an employee of the company, put it another way, because we are stipulating that he was in the course and scope, and because there are no gross negligence claims or no valid gross negligence claims, submitting to a jury both negligence of the driver and the company would be redundant and superfluous. And under those situations, what courts have said is that it's irrelevant whether or not he was competent or not, because the company is already liable for his actions based on his own negligence. So based on that, Your Honor, we're here today to ask for summary judgment on gross negligence claims against both defendants, negligence per se claims against both defendants, and then also the direct negligence claims against Dynamic Glass only.
Okay, and that last part is based on a stipulation as to not only course and scope, but negligence of the driver?
We're not stipulating a negligence. Well, I'll say this. There is some dispute as to the percentage of negligence between both parties. We are arguing that he was a cause of the accident because of his left turn, but we are not arguing that he is 100% at fault. There is some evidence and some responsibility that we will show a jury at trial that they should consider her negligence as well.
Okay, I'm not following the very last. You want the court to say that the company wasn't negligent, but you won't admit that your employee was?
Not for any respondeat superior claims, Your Honor. I'm talking about the direct negligence claims only against Dynamic Glass. For example, negligent hiring, negligent training, negligent supervision, and negligent retention. Those are claims that were brought against the company, and their arguments are that they did not properly train him or supervise him as some sort of proximate cause of this accident. But if I can share my screen, Your Honor, would that be possible?
Yes.
Okay, and let me just scroll down real quick to the part where I can get to it. Okay, this is the respondeat superior admission rule, which basically says that where there is ordinary negligence that's been alleged, as in this case law supports the appellate's contention that negligent hiring and respondeat superior are mutually exclusive modes of recovery. In cases where the plaintiff was relying upon a theory of negligent entrustment, in that case it was negligent entrustment. There is case law cited in our brief that courts have also applied this to negligent hiring and training, etc. In cases where a plaintiff is relying upon a direct negligence theory against the company, courts have refused to permit the plaintiff to proceed with a separate ground of recovery against the company where the derivative liability of the owner has already been established by an admission or stipulation of agency or course and scope of employment. And of course, the rationale on that, Your Honor, is that because you can only get one set of damages if the driver is found to be negligent, and because we have stipulated the course and scope, then through vicarious liability, through respondeat superior, we are responsible. The company is responsible for the driver's negligence. And so his negligence is separate and apart from the negligence of the company in terms of negligent hiring and supervision. There are also some other cases that have been cited in our brief that I just kind of mentioned here in terms of the holdings. But as this court said, there's no issue left to submit to the jury on whether or not things like negligent entrustment, hiring, etc., should be submitted to a jury. And then finally, the Supreme Court says once the applicability of the respondeat superior doctrine is established, the relative competence of the employee and the degree of care exercised by the employee becomes immaterial, and evidence as to such competence and degree of care is inadmissible if there is not a viable gross negligence claim. So again, because we have stipulated that he was in course and scope, and we are going to be responsible for his negligence for his driving on that particular day of the accident, and because there is no viable gross negligence claim under this respondeat superior admission rule, only the direct negligence claims against the company should be dismissed.
Okay, I think I understand. I'm going to take a look. Did you send in a proposed order, Mr.
We
Baker?
did, Your Honor.
Okay. Let me see if I can track it down.
Yes, and that proposed order, Your Honor, did kind of break out the different claims because, you know, like I said, they're not all against both defendants, if that makes sense. They were separated out in the petition.
Okay. I'm going to grant the summary judgment. I'm going to go over, I think the order, I understand what we're doing here, but I'm going to take a few extra minutes after the hearing is over to
Yes,
review
ma'am.
it further. You'll get it once it's signed and sent over to the clerk.
Yes, ma'am. And again, I just want to reiterate to the court, the negligence claims against the driver still survive, and we will be going to trial on those particular claims.
Got it. So good luck on the 27th of January.
Yes, ma'am. Yes,
Y'all
ma'am.
mediated, I take it.
We did, and we've had extensive discussions after the fact. Yes, ma'am.
Well, there will be a judge and jury available.
Okay.
So
Thank you. I appreciate
you
it.
are excused.
Thank you, Your Honor.
Okay, take care. Were you able to get a hold of the opposing lawyer?
I was.
And what did-
David Payne, he doesn't plan to participate.
Okay. Well, that is good to know. All right.
It'll be even shorter.
Yeah. Do you have a proposed order you sent in?
I did. I put it in the box and I also sent it to your clerk in the Word document yesterday. So to Miss Seeger.
Okay, let me see. I think I have it here.
It should be in the box also. We submitted it in the box.
Sure, I've got it here in my email. Box is a little cumbersome.
Agreed.
Great for the court reporter, but it takes, let's see. All right, so they filed their counter affidavit late.
Yeah, 88 days
And
late.
yeah, that's a while. And they didn't file a response.
No, ma'am, I did not.
And they're not here to stand up for themselves or why it's late or begging for mercy.
Correct.
All right, well, I'm going to grant the motion to strike, seeing no argument to the contrary. I'll get the order signed. You are free to go.
Thank you, Judge. Have a great day, and thanks
You
for
too.
letting us participate remotely.
Yes, stay safe and warm out there.
Thank you too.
All right. Okay, we're going to go back to our summary judgment, Pelton versus Middleton. And let's see, we're going to take up the objections here first. So we'll call cause number GN 23-000759 Helton versus Middleton Construction et al. You may make your appearances.
Riker Rory for the movement. Third party defendant, Andy Carr.
And Kendall Bryant for defendants and third party plaintiffs, KWM Austin Investments LLC and Keith Middleton. And there's other defendants I represent that are in the style.
Will Palmer on behalf of plaintiffs, Sherry Spiller, Daniel Helton, and Jarrett Janicek.
Okay. Okay, let's go over the objections, get those arguments on the record while our court reporter is here.
Sure, Judge. I filed some objections to the Mr. Carr's affidavit. Essentially, there's some portions that I believe where he asserts certain things that are contradicted in his deposition testimony. And so I pointed those out in my objections. And then I also provided the court with sort of a check the box proposed order on the objections. And so the first one is related to portions of paragraphs 5 and 9. Mr. Carr asserts that Keith Middleton acted against his advice when signing the security agreement, sales agreement, and fixed rate promissory note on December 5th, 2013. I objected to those statements as self-serving and contradicting his own deposition testimony. His testimony, and then I cut and pasted this into the body of my objection, says, question, did you give him any advice on how to consummate the transaction to purchase Spiller custom hitches via the documents you gave him? Answer, I don't recall. And so I'm going to object to his portion of the affidavit that says Mr. Middleton acted against Mr. Carr's advice.
Okay.
And then
okay. Do you want to take them one by
yeah, that works. Yep.
Any response to those objections?
Yes, Your Honor. Mr. Carr's response to the deposition question is, I don't recall, not that he did not give advice. It's that he didn't remember at the time of the deposition. But further, the question also says, and I'm just looking at the copied and pasted version here. It says, did you give him any advice on how to consummate the transaction to purchase Spiller custom hitches via the documents that you gave him? So I think this can also be interpreted in two ways. It could be interpreted as asking if any advice was given via the documents that were given. So that itself is different than what is being said in the affidavit, where he's just saying, I didn't advise him. That advice can be oral or written.
Mr. Palmer, I take it you don't have anything to add to this one way or the other?
No, Your Honor, I don't plan on speaking much during this hearing.
Okay, fair enough. All right. I think what I am going to do, counsel, is I'm going to carry these objections forward with the motion itself. So I'm not going to rule on them here in the courtroom. I do have the order that's been provided with them enumerated. So I will rule on them, but I want to get all the arguments out while we're here together. So Ms. Bryant, you can move on to the next one.
Okay, the next objection we have is to paragraph 8, that Mr. Carr states that Mr. Middleton did not sign the certificate of formation on November 26, 2013. I've objected to that statement as self-serving and contradicting his deposition testimony. On page 42, lines 14 through 15 of his deposition, he states, I don't know when he signed the sales agreement. And then as to paragraph 9, Mr. Carr states Mr. Middleton acted against his advice when signing the sales documents. And in his deposition, he states, question, and you say that you made a recommendation that he wait until all relevant documents were received back. Do you have any evidence to show that you made that recommendation? Answer, not off the top of my head, if it's not in something that has been produced.
Response?
Yes, Your Honor. So again, the affidavit says that the documents were not signed and returned to him on that day. They do not simply just say that they weren't signed. We agree and admit that we don't know on what day the documents were signed, but the affidavit specifically says that they were not signed and returned to Mr. Carr on that day, and that's undisputed by either side. And that's with regard to paragraph 8. With regard to paragraph 9, I think the objection was that Mr. Carr says he does not have any evidence to show, or the question was, do you have any evidence to show that you made that recommendation? Mr. Carr says, not off the top of my head, if it's not in something that has been produced. Again, this is kind of our same response to the previous objection. He's just saying he doesn't remember at the time of this deposition if it's not something that has been produced. Something that was produced and that is attached to the summary judgment motion is a letter wherein he says, do not operate business until the business is formed.
Right, Judge, but we're specifically objecting to the statement that Mr. Middleton acted against Mr. Carr's advice. Statement, not necessarily the whatever has, the evidence has been produced.
Okay, so we're talking about paragraph 9, I believe.
Right, of the declaration.
Okay. All right. Well, I'm going to go through these a little bit more carefully after the hearing. So I will get you the rulings on them, but for now, I'm going to take it under advisement.
Thank you.
Yes, Your Honor.
Okay. And that covers all the objections, right?
Yes.
Okay. And we're ready to let Miss Simon get to her transcripts and mountain of work that she otherwise needs to take care of.
That's okay.
Yes, Your Honor.
Okay. Thank you, Janice. You're free to go. Take care. All right. And now you may go ahead. Go ahead with the arguments on the motion itself.
Thank you, Your Honor. Your Honor, just to give some brief background on the case, and I'm not going to go through the case in regards to the plaintiff and the defendants themselves, because that's not very relevant to the motion at hand. The motion is simply about the relationship between the third-party plaintiff and the third-party defendant. And just to give a little bit of background, the third-party defendant is Andrew Carr, who is acting as third-party plaintiff Keith Middleton's attorney. And the complaint against Mr. Carr is that he committed legal malpractice. And Your Honor, just to give a little bit more background, the events in controversy, meaning the events between Mr. Middleton and Mr. Carr occurred in 2013. So it's quite a long time ago. And that kind of begins a little bit of our summary judgment here, is that we believe, first of all, this is well past the statute of limitations. For a legal malpractice claim, the typical statute of limitations is 2 years. Now, third-party plaintiff has asserted the discovery rule, saying that the inherent facts were not discoverable until less than 2 years ago from when they filed their petition. And here's just a little bit of background as to what exactly was going on. So Mr. Carr was engaged in order to help Mr. Middleton form a company for the purposes of acquiring or purchasing a business. And the company is KWM. On November 26, 2013, Mr. Carr sends to Mr. Middleton certificate of formation and other documents that need to be reviewed and signed by Mr. Middleton to help form the company. On November 16th, and these are dates that are undisputed, they're both in our motion and in third-party plaintiff's response. On December 16th, Mr. Carr emails Mr. Middleton saying that he still needs the documents. He doesn't have them. Meaning on December 16th itself, Mr. Middleton knows that Mr. Carr has not formed the company because he doesn't have the signed documents. Sometime between December 16th and December 18th, Mr. Carr does get the signed documents and forms the company, December 18th, 2013 being the formation date. And it's unknown when exactly Mr. Middleton signed these documents. The documents are dated November 26th, which is the date that Mr. Carr forwarded the documents for signature and review. Mr. Carr said in his deposition that they had that date because that was the date that auto-populated when he made the forms, but we're unsure of the exact date they were signed. Nevertheless, on December 16th, Mr. Carr still didn't have them. When he got them, he went ahead and filed and formed the company. The problem Mr. Middleton has now with Mr. Carr is that Mr. Middleton conducted business on behalf of this company. He's signed a purchase and sales agreement. He signed a promissory note prior to the formation of the company. Now, this is contradictory to the advice that Mr. Carr had given Mr. Middleton, including in an engagement letter, wherein he says, do not conduct business until the company is actually formed. This is Mr. Carr is aware that Mr. Middleton is trying to enter into these agreements regarding this company. That is why he's telling him, hey, I need your signed documents. When he gets them, he goes ahead and forms the company. It's important to note, too, that Mr. Carr does not actually know a lot of what's going on between Mr. Middleton and the parties in which Mr. Middleton's engaging with to purchase this company. The plaintiffs in this lawsuit and Mr. Middleton have a long-standing history. They've known each other for many years. They were working directly together for a lot of this. And once Mr. Carr got the documents, he went ahead and formed the company. Now, what Mr. Middleton is saying is that it is now Mr. Carr's fault that the company was not formed until after the purchase agreements and the promissory note were already signed, and that because that has led to individual liability for Mr. Middleton, Mr. Carr is now responsible. Your Honor, we believe there's no evidence to support this claim. There cannot be any breach shown because first, we have a statute of limitations issue. All of this occurred in 2013. The discovery rule does not apply because on December 16th, which is after Mr. Middleton had already signed these company documents, he knows that the company has not been formed because Mr. Carr is emailing him saying, I don't have your signed agreement. I don't have any of your signed documents. I need these from you. At that time, Mr. Middleton knows the company has not been formed and he's already signed the agreement. If there was a breach, Mr. Middleton is aware of this in December of 2013. Regardless, even setting that aside, even if there is something to look at today, prior to Mr. Carr forming the company, he had explicitly advised Mr. Middleton to wait until the company was actually formed before entering into any agreements, before moving forward with business. His engagement letter specifically says, do not conduct business until the company is actually formed. Again, this is basic advice. This is transactional advice. This is something that Mr. Carr told to all of his clients in these situations. And it's the same thing he told to Mr. Middleton. Mr. Middleton chose to disregard that and go ahead and sign documents relating to the company, even though Mr. Carr specifically tells them it's more important to get it done right than to do it quickly. So Mr. Middleton chose to enter the agreement. He intentionally disregarded the advice that was given to him and went ahead and formed and entered into agreements on behalf of the company, knowing the company was not formed. This cannot be the fault of the attorney because this is going against the advice that was given, and this is doing acting on his own accord. So even if the court were to decide that the statute of limitations does not apply and that we can look at this still, there's still no evidence to support the fact that Mr. Middleton went ahead and signed the agreement relying on Mr. Carr's advice. In fact, a traditional summary judgment works here too because it's the opposite. Mr. Carr advised Mr. Middleton to not do this, and Mr. Middleton did it anyway. Your Honor, we're just asking that the one claim that's being lodged against Mr. Carr, this a malpractice claim, be dismissed because there is no evidence to support it. And even on a traditional summary judgment grounds, the third-party plaintiff cannot prove that there's a genuine issue of material fact.
Okay, Ms. Bryant.
Sure. So I just want to make clear to the court, the only portion that the third-party defendant has alleged in their traditional motion for summary judgment is related to the discovery rule. So I'm going to address that first, and then I will address the no evidence portion of their motion. So we are arguing that the discovery rule applies to this case. They cite a case called the Hughes rule, and I will discuss that in a second and why that doesn't matter to how the discovery rule applies to how we learned of the legal injury. So my client, Keith Middleton, did not discover the legal malpractice injury by Mr. Carr until February of 2023 when he was served papers for this current lawsuit alleging he had personal liability for the promissory note. We have a detailed outline or timeline on page 5 of our response that may help you because there's a lot of dates. And essentially this personal liability issue boils down to what I call like a date signing issue. So essentially, Mr. Middleton is given documents, a sales agreement, a promissory note, a certificate of formation to form this LLC by Mr. Carr. Those documents get revised. Then Mr. Middleton and all the other sellers sign the documents around December 5th up until December 18th. And then on December 16th, Mr. Carr emails Mr. Middleton and said, oh, I still need the signed certificate of formation for KWM. And then he goes and signs it. So I'm going to talk about that later because first I want to talk about the discovery issue. I agree with Ms. Royalty that a legal malpractice claim has a 2-year statute of limitations, but it's after the cause of action accrues. Accrual is the relevant term. The accrual happens when quality professional advice is taken. However, under the discovery rule, accrual is deferred until the client discovers or should discover the wrongful act and injury. We cite a case in our response. It's Willis versus Maverick. It's a Texas Supreme Court case from 1988, and it states that legal malpractice claims are inherently undiscoverable because it is unrealistic to expect a layman client to have sufficient legal acumen to receive an injury at the time of the negligent, or to understand an injury, perceive an injury at the time of the negligent act or omission by the attorney. So we're essentially saying, yes, he did legal work for him in 2013, but until 2023, when the current lawsuit was filed, we didn't know about the issue that could potentially result in personal liability of Mr. Middleton. When a defendant, and here this is Mr. Carr, moves for summary judgment on the basis of limitations, and Mr. Middleton, raises the discovery rule, then the defendant must negate the discovery rule rule by proving as a matter of law there's no genuine issue of material fact about when the plaintiff discovered or should have discovered the nature of the injury. Mr. Carr has offered no evidence whatsoever of when Mr. Middleton discovered or should have discovered the nature of this injury. And furthermore, and this is in our client affidavit, Mr. Middleton did not discover, based on the exercise of reasonable diligence, until he was served with the papers alleging he was personally liable for the debts of KWM Austin Investments. And this goes directly to the Willis case because Mr. Middleton's claim against Carr was inherently undiscoverable because as a layperson, he did not know, and he entrusted this matter with Mr. Carr to timely and take care of the sales transaction and take care of forming this company to have him not be potentially personally liable for these debts. And the reason why this case got filed so much later was there's a promissory note in addition to the sales agreement, and the promissory note allowed for payments for the purchase price of Spiller Custom Hitches over a period of 10 years. And Mr. Middleton, through his company, made the payments to the plaintiffs for a number of years. And then with COVID and various other business things that happened, I'm sorry, my screen just went out. He quit making payments. And so he breached the promissory note. The company breached the promissory note. And that's when the breach of promissory note cause of action accrued. And until that time, he had no knowledge of any issue with him being potentially liable personally. The defendants cite the Hughes case as not applicable to this case, and we're not relying on the Hughes case. What the Hughes case says is an additional tolling mechanism specifically related to attorney malpractice claims. It tolls all statute of limitations until all appeals of the underlying claim are exhausted. So we're not even to that point. We don't need to rely on Hughes. We're relying on the discovery rule. So I believe that portion, the traditional portion of the motion for summary judgment on statute of limitations should be denied because they were properly told under the discovery rule. Okay, so as to the attorney malpractice claim, I think I quickly went through the timeline, but I might refer back to it. Again, that's on page 5 of 18 of our response. So as you heard earlier from counsel, Mr. Carr repeatedly states that he gave Keith Middleton advice to refrain from conducting any business until KWM was formed with the Secretary of State. However, this advice does not equate to Mr. Carr telling Keith Middleton not to sign the sales agreement and promissory note that he had provided to him prior to KWM being filed. So in early November, they start emailing about this transaction and that Carr is going to act as Middleton's attorney. This is all we have citations. This is all in Exhibit B in our evidence. In the middle of November, Mr. Carr emails Mr. Middleton and says items needed, gives him information he needs to start working on the sales transaction. On November 26th of 2013, Mr. Carr provides Mr. Middleton with a letter regarding the formation of KWM Austin Investments, LLC. This letter includes, as an enclosure, an unsigned certificate of formation for KWM. Then on December 2nd, Mr. Carr emails Mr. Middleton the documents related to the purchase. That includes the Spiller sales agreement, the security agreement, a confidentiality agreement, the promissory note, and another copy of the KWM certificate of formation. On December 3rd, Mr. Middleton emails Mr. Carr, there's a name typo in the documents that he wants corrected. On December 3rd again, he requests additional changes to the documents. Later that night, on December 3rd, Mr. Carr emails Mr. Middleton copies of the quote Spiller revised documents. Then on December 4th, Mr. Carr emails Mr. Middleton regarding the sale, stating, I know the sellers are pushing all kinds of pressure on you to get this deal signed, but I would tell them to be patient. Getting this right is more important than done. Then there's no emails between them. And then until December 16th, when Mr. Carr emails Mr. Middleton stating, I still need the signed certificate of formation for KWM. And so what we have shown and what we show in our attorney malpractice expert affidavit is that Mr. Carr was entrusted with getting all of these documents properly signed and executed, including getting the KWM certificate of formation signed and filed properly with the Secretary of State. He knows that it's a problem if Mr. Middleton signs it too early because he says, don't do any business, but he's given him these packet of documents and he doesn't ensure, he gives him the final version, the revised version of the sales agreement, but then doesn't ensure for at minimum 12 days that he hasn't signed the documents before he gets the certificate of formation signed. That's essentially the crux of our argument. It's not that he says, they again rely on don't do any business. Don't do any business is different than don't sign the sales agreement that I've given you to sign. I also asked him in his deposition, and this is in our evidence, is it customary for you to give your clients, lay people, packages of documents and then never follow up on what they did when they signed them? And he said, no, that wouldn't be customary. So as an attorney, he was entrusted to make sure this deal was done properly, and he failed to do so. And that is in our evidence with Mr. Middleton's statement that he didn't know how to consummate this transaction on his own. He relied on the advice of Mr. Carr, and in Gaines West's affidavit that states the same thing, that he was entrusted to make sure this deal was done properly, and it was malpractice for him not to do so. And I think you can read into his language in his December 16th email and said, I still need the signed certificate of formation, meaning he knew all along that he needed to get it, and he needed to get it formed because Mr. Middleton already had the final documents that he was going to go get signed from all the sellers, and he himself was going to sign. I think I said this earlier, but there's no specific evidence of Mr. Carr stating to Mr. Middleton, don't sign the document, don't sign the promissory note or the sales agreement before I get KWM formed. He generally says, don't do business. And so at minimum, I think there's a fact issue of whether doing business is enough advice to your client that that has entrusted you with this matter to understand that means don't sign the completed documents that I've given you. And I think that for that reason, the motion fails. We go through in our response the standard of care that an attorney is held to, the failure to exercise ordinary care by an attorney includes giving bad advice, failing to give advice or opinion when obligated to do so, disobeying a client's lawful instruction, delaying or failing to handle a matter entrusted to the attorney's care by the client, or other improperly representing the client. And I believe from the facts and evidence shown that Mr. Carr failed to handle the matter entrusted to him, which included not only getting the LLC formed properly, but making sure all of the sale documents were done properly. Mr. Middleton is a layperson. He's in the construction industry. He did not know how to form companies or buy companies. That's what he entrusted Mr. Carr to help him do. And the last thing I have to say is that the third party, Mr. Carr tries to say that but for Mr. Middleton's actions, this wouldn't have happened. But I think but for Mr. Carr's failure to ensure that the documents were signed properly on the dates, that he didn't ensure, he'd given him this blank LLC certificate of formation. He did not ensure that document was filed with the Secretary of State prior to Mr. Middleton signing the promissory note. And but for that failure, Mr. Middleton would not be personally liable for the debt. That is the baseline of our argument. And I think that we have very much provided much more than a scintilla of evidence that we survive this no evidence summary judgment, and we believe this should go to a judge or a jury.
Ms. Doherty, you get the final say.
Your Honor, just very briefly, I think again, our main point here still stands. This occurred more than 10 years ago. Mr. Carr and Mr. Middleton, in addition to having email conversations, they also had verbal conversations. But with regard to the written documents that have been provided, there is undisputed a letter wherein it is stated that he should generally not conduct business. And I understand Ms. Bryant is saying that specifically Mr. Middleton was not advised, don't do this particular thing and don't do that particular thing. Don't sign this, don't do that. But Your Honor, the fact that Mr. Carr said, generally, just don't do anything regarding the company, that is enough. That is enough of a blanket statement to cover what he needed to do under the rules. Thank you.
Okay, I am going to take a look. I'll probably have an answer for you next week.
Thank you, Judge.
All right.
You, Judge.
Happy New Year. Best to you. Y'all are excused.